before this court orders me to move my gate. Your Honor, I'd like the HOA to show you exactly where their property begins." The words came out calmer than I felt. Across the courtroom, Cynthia Whitmore sat beside her attorney with both hands folded over a cream-colored folder, wearing the same polished smile she had worn for 6 months while telling everyone in Briar Glen Estates that I was an unreasonable landowner holding an entire neighborhood hostage. The fluorescent lights hummed above us. Somewhere behind me, an old wooden bench creaked. I could smell burnt courthouse coffee, floor wax, and the faint paper and dust scent of records that had been sitting in county cabinets longer than some of the houses Cynthia claimed to represent. Judge Rebecca Holloway looked over her glasses at me. "Mr. Mercer, the question before this court is fairly straightforward. Briar Glen alleges that your gate obstructs its primary residential entrance. Are you disputing that residents use this entrance?" "No, ma'am." Cynthia's smile widened. Her attorney shifted forward as if I had just handed him the case. The judge tapped one finger against the photograph lying beside her. It showed my black steel gate stretched across the paved entrance, with Briar Glen stone columns rising behind it and their polished brass sign catching the afternoon sun. "Then if this gate belongs to you," she said, "why is an entire subdivision using the road behind it?" That was the question Cynthia had spent thousands of HOA dollars bringing us here to answer. She thought the answer would force me to unlock the gate permanently. She thought a judge would declare that entrance theirs, order me out of the way, and turn 6 months of threats, certified letters, survey arguments, and neighborhood gossip into one clean victory. I glanced at my attorney, Nathan Briggs. He didn't speak. He simply rested his palm on a rolled survey map beside his legal pad. I could hear the soft crackle of the paper beneath his fingers. That map was why I wasn't nervous anymore. 6 months earlier, I hadn't known it existed. Cynthia still didn't understand what it showed. Neither did most of the people sitting behind her. Judge Holloway leaned back. "Mr. Mercer?" I looked toward Cynthia. Perfect blonde hair, navy blazer, pearl earrings. Not a trace of doubt on her face. Then I looked back at the judge. "Your Honor, I'll answer that question. But first, I think their attorney should identify the exact property line they're relying on." Cynthia whispered something to her lawyer. His confidence flickered for half a second. Nathan slowly untied the red ribbon around the survey. The paper rolled open with a dry snap that seemed impossibly loud in that quiet room. A thin red boundary line crossed the page. It passed through my gate, continued beneath Briar Glen's stone entrance monument, and kept going farther than Cynthia could possibly have expected. That was when I remembered what my father had told me 27 years earlier, standing beside an oak tree with red Tennessee clay stuck to his work boots. Roads change, steel disappears, but property lines don't move. And Cynthia Whitmore had just taken me to court without checking where hers actually was. 6 months earlier, that property line was the last thing on my mind. My name is Daniel Mercer. I was 46 years old, and I had spent most of my adult life moving dirt for people who wanted to put something permanent on top of it. Foundations, drainage systems, retaining walls, access roads. My company was small enough that I still climbed into the excavator myself when somebody called in sick, and after 23 years in grading and site preparation, I had learned one rule that never failed. The ground remembers what paperwork forgets. Laura and I lived on 11 acres outside Franklin, Tennessee, on land my father bought in 1989. Back then, Briar Glen Estates did not exist. There were soybean fields behind us, 2 cattle fences, a narrow gravel lane, and enough darkness at night to see stars all the way down to the tree line. Dad built our gate himself. Black steel tubing, welded hinges, 2 square posts sunk deep into Tennessee clay. Nothing decorative, nothing fancy. It was built to work. I was 19 when I helped him set the western post. I can still remember the smell of hot steel from his welder, mixing with wet earth after an afternoon storm. Cicadas screamed from the oak trees while Dad checked the post with a level that looked older than I was. About 20 feet away, near a wide white oak, he stopped and scraped dirt aside with his boot. A small metal survey pin sat almost flush with the ground. He pointed at it with his work glove. "Remember that marker, Danny?" I laughed and asked why I would ever need to remember a rusty piece of metal buried in weeds. Dad looked toward the gravel lane. "Because roads change. Steel disappears. Property lines do not move." At 19, I thought it was just another one of his sayings. Dad had plenty of them. Measure twice. Never trust fresh fill after rain. If somebody says a boundary is obvious, ask for the survey. I remembered the lessons because I became a contractor, but I never imagined one of them would eventually decide whether strangers could claim the entrance to my own property. Dad died 8 years before the lawsuit. The 11 acres came to me through his estate, along with the old workshop, his battered red toolbox, and 3 cardboard boxes of property records I barely touched. I kept paying the taxes. I maintained the drainage ditch. Every few years, I greased the gate hinges until they swung without a squeak. Then development arrived. First came survey crews in orange vests, then bulldozers, then the smell of diesel every morning and the steady beep of equipment backing through what used to be soybean fields. Within 2 years, Briar Glen had 87 houses behind us, each with fresh sod, matching mailboxes, and porch lights glowing in neat rows after sunset. Their original entrance was almost half a mile east of my driveway. For a while, that meant nothing to me. Then one Saturday morning, Laura set her coffee mug beside the kitchen window and said, "Daniel, were you expecting landscapers?" I looked outside. 3 men were planting flowers beside my gate. Behind them sat a white sport utility vehicle I had never seen before, and leaning against the hood, holding a clipboard like she had arrived to inspect something she already owned, was Cynthia Whitmore. The woman did not introduce herself until after she had already told one of the landscapers to move a stack of limestone closer to my fence. I walked down the driveway with gravel grinding beneath my boots, still carrying the coffee Laura had poured me. Fresh mulch hung thick in the morning air. Cynthia watched me approach, then gave me the kind of professional smile real estate agents use when they already expect your signature. "Daniel Mercer?" she asked. "That depends on why you are planting flowers on my property." Her smile tightened. "Cynthia Whitmore, president of the Briar Glen Homeowners Association. We are improving the western entrance." I looked past her. The landscapers had cut a clean crescent into the grass beside my gate. Red begonias sat in black plastic trays. A pallet of stone rested near the ditch. "You mean my driveway?" Cynthia glanced at her clipboard. "The community has been using this access point for some time." That was technically true. During construction, delivery trucks had occasionally used the gravel lane to turn around. After the houses opened, residents discovered it was a faster route to the county road. I had tolerated it because most people slowed down and waved. Tolerance, I would learn, was a word Cynthia interpreted as surrender. "Using something does not make it yours," I said. She gave a small laugh. "Nobody is trying to take anything, Mr. Mercer. We are formalizing an existing community entrance." I set my coffee on the gate post and pointed toward the stone pallet. "On whose land?" For the first time, she stopped smiling. Only for a second. "Our planning documents identify this corridor as part of Briar Glen access." "Show me the easement." Silence. A sprinkler hissed from one of the new lawns behind her. Cynthia looked down at her papers, then back at me. "I do not carry every association document in my vehicle." "Then stop the work until you find the one that gives you permission." She stared at me as if I had refused a perfectly reasonable request to move my own house. The crew stopped by noon, but the flowers stayed. 3 days later, a truck arrived with 2 stone columns. A week after that, low-voltage lights appeared along the pavement. Then came the polished brass sign, Briar Glen Estates. Each addition crept a few feet farther into the landscape, turning the entrance into something that looked official enough that nobody thought to question it. I did. I photographed everything. I measured from the old oak tree. I searched the county website for recorded easements and found nothing that matched what Cynthia claimed. When I called her, she sounded almost amused. "Daniel, you are making this much more complicated than necessary. Send me the recorded access agreement. Our attorneys have reviewed the matter." "That is not what I asked." Her voice cooled. "This entrance benefits 87 families." There it was. Not ownership, not permission. Benefit. Cynthia believed enough people using my land could somehow erase the word "my" from the sentence. Then the letters started. The first envelope arrived on heavy cream paper with the Briar Glen logo printed across the top. It called my gate an unauthorized obstruction affecting community access. The second demanded that I leave it open from 6 in the morning until 10 at night. The third mentioned property values. I placed all 3 beside Dad's old toolbox in the workshop. Laura read them twice, then looked toward the gate through the dusty window. "She is not asking anymore." I could hear a landscaping mower humming beyond the trees. I folded Cynthia's latest letter along its original crease. No, I said. Now she is creating a paper trail. What neither of us knew yet was that I was about to create one too. Then one Thursday evening, I came home to find the gate standing wide open. The chain I used to secure it had been removed and placed neatly on the grass. Nothing was damaged. That almost made it worse. Someone had simply decided my lock was an inconvenience. I closed the gate, threaded a new chain through the steel bars, and secured it with a heavy brass padlock. The next morning, horns woke Laura before sunrise. By 6:30, 7 vehicles were lined up behind the gate. Red brake lights glowed through the mist. Somebody leaned on a horn long enough to make our kitchen windows seem to vibrate. I pulled on my boots and walked outside. The air smelled like wet grass and cold exhaust. A man in a pickup lowered his window. "Can you open this? I have to get to work." "The county entrance is half a mile east," I said. He looked confused. "Cynthia said this was our main entrance." Before I could answer, her white sport utility vehicle rolled up behind the line. Cynthia stepped out wearing a navy coat and carrying her phone. She marched toward me while recording. "Open the gate, Daniel. Good morning to you too. You cannot lock the entrance to our neighborhood." People were watching from their vehicles now. That was exactly what she wanted. An audience. I rested one hand on the cold steel post. "Then prove it is your entrance." Her jaw tightened. "We have maintained this area for years. Maintenance is not a deed. Residents have established access." "Then show me the recorded easement." She lowered the phone slightly. "You are deliberately disrupting 87 households because you refuse to cooperate." I pointed east. "Their legal entrance is open." She looked toward the line of cars, then back at me. "This is going to cost you." 3 days later, another certified envelope arrived. This one came from a law firm in Nashville. It demanded that I remove the gate or provide unrestricted access within 10 business days. It cited traffic safety, established use, and alleged interference with community infrastructure. Laura stood beside me at the kitchen counter while I read it. The refrigerator hummed behind us. Rain tapped against the window. "Are they actually threatening to sue?" she asked. "They are trying to make me believe they already won." I called Nathan Briggs the next morning. Nathan had handled property disputes for contractors I knew, and he had the irritating habit of getting quieter when something interested him. He read Cynthia's letters without speaking. Then he studied the subdivision map I had printed from the county website. "Do you have the original survey from when your father bought the property?" he asked. "Probably. There are boxes in the workshop. Find them. You think the gate is enough to beat this?" Nathan slid the HOA letter back across his desk. "Daniel, I am less interested in the gate than I am in the ground underneath it." 2 weeks later, a process server walked up my driveway carrying a thick envelope. Cynthia had stopped threatening court. She had filed. The lawsuit arrived in a white envelope thick enough to feel expensive. I stood at the kitchen counter turning page after page while Laura read over my shoulder. Briar Glen wanted a permanent injunction forcing me to provide unrestricted access through the gate. They wanted attorney fees. They wanted the court to recognize what they called a long-established community access corridor. By the time I reached the final page, my coffee had gone cold. Nathan warned me not to underestimate them. Cynthia had hired a firm that represented developers across Middle Tennessee, and their first evidence package looked impressive. There were recent subdivision maps showing the western entrance highlighted in green. There were landscaping invoices going back nearly 5 years. There were maintenance records for pavement, lighting, sprinklers, and stonework. They had photographs of residents using the road every morning. They even had statements from homeowners who said their real estate agents had described it as a Briar Glen entrance when they bought their houses. Cynthia had spent years making the place look like HOA property, and now her lawyers were using that appearance as evidence. Nathan spread the documents across his conference table. The air conditioner clicked above us while I stared at one map after another. "They do not need to prove they own your gate to make this expensive," he said. "They are going to argue access rights, reliance, established use, and whatever else they can support. But they still need an easement. A recorded easement would make their life easier. The absence of one does not make our life simple." Cynthia, meanwhile, acted like the ruling had already happened. After the first scheduling hearing, she caught me outside the courthouse beneath a row of limestone columns. Her heels clicked sharply against the sidewalk as she approached. "You can still make this easy, Daniel." I kept walking. "Easy for who?" Once the judge orders that gate removed, all of this ends. You are spending money to delay the inevitable. I stopped. She smelled faintly of expensive perfume and peppermint. Then show me the document my father signed. Her expression did not change. Your father is not the issue anymore. That sentence stayed with me. That night, I went into the workshop and pulled Dad's 3 cardboard boxes from the shelf. Dust coated my fingers. I found tax receipts, equipment manuals, old insurance papers, and photographs faded almost yellow at the edges. Nothing that looked like the original survey. 2 hours later, Laura came in carrying another box she had found behind Dad's red toolbox. At the bottom was a folded county plat from 1989. I opened it across the workbench. The paper smelled like dust and machine oil. Dad's parcel was outlined in black ink. I followed the boundary toward the road, then stopped. Every modern map Cynthia had submitted showed Briar Glen's western entrance as a clean corridor between 2 property lines. Dad's plat showed something different. There was a narrow strip of land extending farther east than I remembered, directly toward the place where Cynthia had built those stone columns. I called Nathan even though it was nearly 10 at night. He listened while I explained. Then he asked one question. Do you remember where the original survey pins are? I looked through the workshop window toward the dark outline of the old oak tree. For the first time in 27 years, I heard my father's voice as clearly as if he were standing beside me. Remember that marker, Danny? At 7 the next morning, I was standing beneath the old oak with Ethan Cole, a 68-year-old surveyor who had spent 4 decades finding lines other people swore did not exist. Fog hung low over the grass. The stone entrance columns were barely visible through it, their landscape lights still glowing pale yellow. Ethan studied Dad's plat, adjusted his glasses, then looked toward the flower bed Cynthia's contractors had installed. If these bearings are right, your corner should be somewhere around there. He pointed directly at a bed of red begonias. I almost laughed. Of course it is. Ethan pulled a metal detector from his truck and swept it slowly above the damp soil. Nothing. He moved closer to the stone column. A short beep broke through the morning quiet. Then another. Beep, beep. The signal sharpened. Ethan crouched and scraped away mulch with a small hand shovel. 3 inches down, metal appeared beneath the dark soil. A survey pin. Old. Rusted. Exactly where Dad's plat said it should be. I stared at that little piece of steel while water dripped from the oak leaves behind us. Cynthia had spent thousands of dollars creating an entrance designed to look permanent. Stone, brass, concrete, lighting, landscaping. Yet the most important object, there was a rusty pin almost nobody could see. Ethan located another marker farther south, then a third near the drainage ditch. He set up his equipment while I watched the morning traffic move through Briar Glen. A laser flashed against the stonework. Ethan checked his readings twice. Then a third time. His expression changed. Daniel. What? He pointed toward the western column. That is inside your parcel. I looked at the column, then at the gate. By how much? More than enough. He moved the instrument and took another reading. I followed him toward the pavement. The boundary did not stop at my gate. It crossed beyond the landscaping Cynthia had installed. It continued under the paved lanes residents had been using for years. Ethan walked slowly along the line, marking temporary points with small orange flags. Each flag made the picture worse for Briar Glen. One landed beside the irrigation box. Another appeared beyond the brass entrance sign. By the time he finished, I could see the shape of Dad's parcel in a way I never had before. The subdivision had not merely borrowed a few feet near my gate. Their decorative columns were on my land. Their sign was on my land. Their landscaping was on my land. Most importantly, the paved western entrance they were suing me for blocking sat inside the same boundary. I folded my arms. How much of the entrance? Ethan looked back at his measurements. All of it. For several seconds, neither of us spoke. Tires whispered over pavement 20 yards away. Somewhere inside Briar Glen, a lawn sprinkler clicked steadily from side to side. I thought about every letter Cynthia had sent me, every demand that I remove my obstruction from their entrance, every invoice her attorneys had produced to prove the association maintained it. They had documented years of spending HOA money on improvements built across property they had never verified they owned. I called Nathan from beside the oak. He arrived that afternoon and walked the line himself while Ethan explained the measurements. Nathan's face stayed almost completely still. That was how I knew the discovery mattered. We need a certified survey, he said, and the complete title history. Then we send it to Cynthia? I asked. Nathan looked toward the Briar Glen sign. Normally, yes. I watched a car pass between the stone columns. Then I remembered Cynthia outside the courthouse telling me the result was inevitable. Not yet. Nathan turned toward me. What are you thinking? I picked up one of the orange flags and rolled the plastic stem between my fingers. She wants a judge to decide who controls this entrance. I looked at the pavement beneath our boots. Let her ask. Dad had never sold that strip. He had never dedicated it to the subdivision. We found no recorded document transferring ownership of it to Briar Glen. Nathan still refused to celebrate. Evidence first, he kept saying. Confidence later. So we built the file. Ethan documented the old pins. I photographed the oak, the drainage ditch, the gate posts, the pavement, and both stone columns. Nathan obtained county plats and archived aerial photographs showing the property before the subdivision was built. Then came my favorite part. Briar Glen's own records started helping us. Their attorneys had submitted landscaping invoices to prove continuous maintenance. Those invoices identified the entrance by location. Lighting contracts did the same. Pavement bills described the western access lane in precise terms. Cynthia thought those documents proved control. To us, they proved the association had repeatedly paid contractors to improve a specific piece of ground. The only remaining question was whose ground it was. One invoice caught Nathan's attention. Cynthia had personally approved more than $18,000 in entrance improvements over several years. Stonework, irrigation, lighting, sign maintenance. Not once in the records we received was there a title report attached. She spent association money without confirming the property boundary, Laura said when we spread the papers across our dining table. Nathan nodded. That may matter to her board later. Right now, stay focused on the land. We offered temporary access while the dispute was resolved, with no admission of ownership or permanent rights. Cynthia rejected it within a day. Her response said the HOA would accept nothing less than unrestricted permanent access. That was when I knew she was still looking at the gate instead of the land beneath it. At the next pretrial conference, I saw her in the hallway speaking quietly with two board members. She noticed me and smiled. Still fighting the inevitable. I looked at the polished courthouse floor between us, just making sure everybody knows where the lines are. She shook her head as if I were being difficult for sport. Nathan touched my elbow and guided me toward the courtroom before I said anything else. That afternoon, the judge set the final hearing date. On the drive home, I passed through the western entrance and watched Briar Glen's brass sign glow beneath its landscape lights. For years, that sign had told everyone who entered that the ground belonged to the community. In 6 weeks, Cynthia planned to ask a judge to make that assumption permanent. I parked beside the workshop and found Dad's old level hanging exactly where he had left it. I ran my thumb across the scratched aluminum edge and thought about the rusty pin beneath Cynthia's flowers. She had stone columns, lawyers, invoices, and 87 households behind her. I had a deed, 3 survey markers, and a line in the Tennessee dirt that had been waiting 37 years for somebody to finally measure it. By the morning of the final hearing, Cynthia had brought enough paperwork to fill 2 banker boxes. I brought 1 rolled survey. Judge Rebecca Holloway entered. Everyone stood, and within 20 minutes Briar Glen's attorney was building the case Cynthia had been promising for months. He showed photographs of morning traffic, maintenance invoices, landscaping contracts, statements from homeowners. Then he placed a large color photograph on the display showing my black gate in front of the stone columns. This obstruction, he said, prevents residents from freely using an established community entrance. Cynthia sat perfectly still beside him. When he finished, Nathan stood. He did not argue about landscaping. He did not argue about convenience. He asked one question. Can Briar Glen identify the recorded boundary of the property containing this entrance? Their attorney pointed toward a subdivision plat. Nathan studied it. That shows the subdivision. I asked about the ground beneath the entrance. The room became quieter. Judge Holloway leaned forward. Counsel, where does your client's property begin? Their attorney turned pages. Cynthia whispered to him. Finally, he said the association believed the entrance fell within its established access corridor. Nathan nodded. Belief is not a boundary. Then he called Ethan Cole. Ethan explained the original deed, the 1989 plat, and the survey markers we had recovered. His voice was slow and precise. Nathan unrolled the certified survey. The dry snap of that paper carried across the courtroom, and suddenly I was back at the moment where this story began. Judge Holloway looked at me. "Mr. Mercer, if this gate is yours, why is an entire subdivision using the road behind it?" I glanced at Nathan. "Your Honor, before I answer that, I would like them to identify exactly where they believe their property starts." Nathan placed the survey on the display. A red line appeared across the image. First came the old oak, then the survey pin beneath Cynthia's flower bed, then my gate post. Nathan enlarged the image. "This is the Mercer boundary confirmed from the deed, the original plat, and the recovered monuments." Cynthia's smile disappeared. The red line continued beyond my gate. It crossed beneath the western stone column. Nathan changed the overlay. The second column fell inside the same parcel. So did the irrigation system. So did the brass Briar Glen sign. Then he widened the image one final time. Both paved lanes of the western entrance sat within the Mercer property. Judge Holloway removed her glasses and looked directly at Briar Glen's attorney. "Does your client own any portion of the entrance it is asking this court to control?" He hesitated. "Your Honor, the association has maintained continuous use." That was not my question. Silence. I could hear the ventilation system humming above us. Nathan placed Briar Glen's own maintenance invoices beside the survey. "These records document improvements made by the association at this exact location." Judge Holloway looked from the invoices to the boundary. "On Mr. Mercer's property?" "Yes, Your Honor," Nathan said. Cynthia leaned toward her attorney, but there was nothing left to whisper that could move a property line. The judge looked at the photograph of my gate one more time, then at the survey beneath it. "The association's request for an injunction requiring Mr. Mercer to remove his gate is denied." Cynthia stared straight ahead. I did not smile. I just watched Nathan roll the survey closed. She had spent 6 months trying to prove my gate stood in the way of her entrance. Instead, her own lawsuit had forced everyone in that courtroom to discover where the entrance had been standing all along. The ruling did not magically erase the problem outside the courthouse. 87 families still needed a practical way in and out, and I had no interest in turning people who had bought homes in good faith into collateral damage for Cynthia's mistake. Nathan worked with Briar Glen's attorney on a temporary access agreement that allowed residents and emergency services to keep using the Western Road while the association developed a permanent entrance entirely within its own property. The agreement was written carefully. Temporary access. No transfer of ownership. No permanent easement. No language Cynthia could stretch into something it was not. For the first time since this started, every word on the page matched the ground beneath it. Then the homeowners began asking questions. They wanted to know why association money had been spent maintaining land the association did not own. They wanted to know why more than $18,000 had gone into stonework, irrigation, lighting, and landscaping without anyone ordering a proper title review. Most of all, they wanted to know why Cynthia had authorized an expensive lawsuit before confirming the boundary she was asking a judge to enforce. 3 months later, construction started on Briar Glen's replacement entrance about 400 yards east, fully inside subdivision property. I knew the contractor. Good crew. They surveyed first. That detail made me smile. On a cool October morning, I stood beside Dad's gate while an excavator idled near the stone columns Cynthia had installed. Diesel drifted through the air. Hydraulic lines hissed softly as the machine lifted the brass Briar Glen sign from its supports. The same entrance that had once looked permanent suddenly looked temporary. Stone came away. Irrigation lines were capped. Landscaping was relocated. Fresh soil covered the places where Cynthia's flower beds had surrounded that old survey pin. I walked over after the crew finished and brushed loose dirt aside with the toe of my boot. There it was. Rusted metal. Barely visible. Still exactly where it had always been. Laura came down the driveway carrying 2 cups of coffee. She handed one to me and looked toward the empty space where the Briar Glen sign used to stand. "All that over a gate," she said. I shook my head. It was never really about the gate. I rested my hand against the black steel post Dad and I had set when I was 19. The paint was faded now. The welds were rough by modern standards. But the post was straight, the hinge still worked, and the boundary beside it had not shifted 1 inch. Dad had understood something Cynthia never did. A sign does not create ownership. Landscaping does not create ownership. Confidence does not create ownership, and enough official-looking paperwork still cannot move a survey marker buried in Tennessee's soil. Roads changed. Briar Glen moved its entrance. Cynthia disappeared from the board. Dad's old gate stayed exactly where he put it. They spent months trying to prove that my gate stood in their entrance. In the end, all they proved was that their entrance had been standing on my land. Justice is not loud. It does not need a clipboard, a polished sign, or somebody shouting about authority. Sometimes justice is smart. Sometimes it is patient. And sometimes it is a rusty piece of steel in the dirt, waiting for someone to finally measure from the right place. So tell me this. If you were in my position, would you have given Briar Glen temporary access while they built a new entrance? Or would you have locked the gate the moment the survey proved the road was on your land? Drop your answer in the comments. And if you enjoy stories where homeowners stay patient, follow the records, and force an overreaching HOA to face the facts, hit like, subscribe, and stick around. Because sometimes the strongest answer is not a threat. Sometimes it is one old survey pin and the patience to let the truth reach the courtroom.